Welcome to rePROs Fight Back, a podcast where we explore all things reproductive health, rights, and justice. I'm your host, Jenny Wetter, and I'll be helping you stay informed around issues like birth control, abortion, sex education, and LGBTQ issues, and much, much more. Giving you the tools you need to take action and fight back. Okay, let's dive in. Hi, rePROs. How's everybody doing? I'm your host, Jenny Wetter, and my pronouns are she, her. So, y'all, I'm going to keep my intro pretty short because we have a long episode today. But I want to talk about something that happened recently. I made a surprise visit to Wisconsin. So, my mom has been serving on the board of the Beloit Health System for 20 years. And has been chairman of the board for the last 11 and has done so many amazing things as chairman and she's just amazing. So they had their last annual meeting with her as chairman of the board recently. And they decided that they wanted to honor all of her work and everything she's done for the board. And so they flew me in to surprise her. And it was so much fun. Like, one, it was just great to get this bonus trip to Wisconsin and time with my mom. But two, it was just delightful to surprise her and see the look on her face when I walked in as they were presenting her with her honors and honoring her for all of her amazing work. It was very exciting. And, one of the things is they're building a new birthing center. And they are naming the family kitchen and relaxation area in honor of her, which is just so delightful. She's so excited about working on that project. And it just made me so happy to see it and to see her overwhelming emotions around that happening and having me there. And it was just really great to be part of that. Just such a proud daughter moment. And then having, I don't know, I think it was like 5 days in Wisconsin and spending time with my mom and seeing some family and going and doing things that have to happen when I'm in Wisconsin, like eating my weight in cheese curds really, I ate my weight in fried cheese curds and it was delightful. What else did I do that was very can only do in the Midwest? Because it was nice out. I went and got a big couple scoops of Blue Moon ice cream, which is something you can only get in the Midwest, and made me so happy. And it was just delightful to see my mom and to honor her. So yeah, very exciting. It was nice to get the little quiet time away. Okay, so with that, let's turn to this week's episode because, like I said, it's kind of a long one. I have two amazing guests on. And they are both from the Health and Human Rights Initiative at the O'Neill Institute for National and Global Health Law at Georgetown University Law Center. Sorry, that is a mouthful, but so they are both from there. And so I have Ivonne Garza and Natalia Acevedo on to talk about the abortion liberalization that has happened in Colombia and Mexico. And so it's a great conversation digging deep into those cases, the court cases, and talking about how those cases were built. And so it was a very interesting conversation. I hope you enjoy my conversation with Natalia and Ivonne. Hi, Ivonne and Natalia. Thank you so much for being here.
Thank you for the invitation, Jenny. We're very excited.
Thank you for having us.
Of course. Okay, before we get started, I like to have my guests introduce themselves and include their pronouns. So let's go. Ivonne, do you want to go first?
Thank you, Jenny, for the invitation. My name is Ivonne Garza. I am a Mexican trained lawyer. I currently work as a senior associate at the O'Neill Institute on National and Global Health Law at Georgetown University Law Center, where we work on issues of health and human rights.
Okay, and I'm Natalia Acevedo. I'm a Colombian lawyer. I'm also a bioethicist, and I'm a senior consultant at the Health and Human Rights Initiative, also at the O'Neill Institute. Thank you for the invitation.
I'm so excited to talk to you too about the court cases from Colombia and Mexico. But I thought, like, before we got there, maybe we should like do a little just like background or like putting it in the landscape of talking about the green wave, just so people before we get to the cases maybe can get a big picture idea before we get focused on two local ones.
So I can start with that. I think it's important for people to know that the region of Latin America has been really moving forward the recognition of abortion as a right. And this is not something unique from Mexico and Colombia. And maybe the image that most of the people have seen in the media is the green wave image of like massive social mobilizations in Argentina when they were trying to approve the law on 2019, 2020. That's like the iconic image that most people saw in the New York Times and other newspapers. So I think that context of increasing social mobilization, it's crucial to understand decisions such as the Colombian one and the Mexican ones, because we believe that social mobilization changed the game and changed how who were involved. We started to see more young people being involved, other sectors of society being involved in these conversations. It was just not something like super legal, but it was like a social conversation going on in many of our countries. So in the region, we have different countries with different legal orders. Some of them have recognized the right to abortion, and currently abortion is legal. Others with really restrictive orders, and that's the region that we have to work on. So that context is important, and we also the green wave. It's also a symbol for like people moving to push the Congress to approve a law, because that's what happened in Argentina. The social mobilization led from years, like many years ago. It was not something from 2018. It was something that started like a long time ago from the feminist movement and women and different people pushing for reforms. But what we saw in Argentina was the approval of a law, which is the law from 2020 that recognizes abortion until week 12 and then respects voluntary interruption of pregnancy in certain circumstances. But what has happened in other countries of the region, it's quite different because it hasn't been like a Congress or legislative change, but a judicial change. So that's like kind of like a difference to what happened to Argentina, but it's connected because it was a movement that pushed organizations to present lawsuits, that pushed organizations to present interventions before these judicial actors. So this, like, I think these reforms have not been possible if that like social mobilization hadn't happened. So yeah, the green wave and the social mobilization that started in the region, of course, created the perfect scenario for these judicial decisions to happen.
Yeah, it just definitely felt like this real energy, like even here in the US, just like, we had seen so many restrictive laws passing at the state level. And so seeing these like this big win happen in Argentina and then start to spread, just you just felt the energy from it.
Yeah, it was really nice, especially in a moment where it's sort of, it was a boom. I remember we were like in the middle of the pandemic and these big things happening in Argentina. It was just like a domino effect for the things we saw happen afterwards. And yeah, it's in the middle of a very also important context where the world was sort of shut down. These big news and big wins for the movement came in and happened, and it was very, very nice to see.
Okay, so maybe let's jump to the first country we're going to talk about and talk about Mexico. And I know there were a couple different court rulings, so maybe let's start with first the one that took on the legalization of abortion.
Well, thank you, Jenny. Something that I think it is important before addressing the two decisions from September 2021, which are, of course, the main discussion for this podcast and super important. I just want to say that give a brief overview of the historical pathway in terms of the jurisprudence that led us to these two resolutions, because even if we recognize that these two decisions were or are landmark decisions for abortion, they had a few background decisions that allowed for these two decisions to happen as they did in 2021. So first of all, something to take into account is that Mexico is a federation, as you know. That is a big difference with other countries in Latin America that are not federal. So with the US, that is something that we can relate with. But it is especially relevant for this issue because criminal law regulates abortion. And if criminal law is a state issue, not a federal one, as it is in Mexico, then the issue of abortion starts with analyzing criminal law and how states interact with that, right? And that's how the jurisprudence was developed. The first cases that came into the Mexican Supreme Court started from an analysis of statutory law and whether or not states had the competency and the authority to regulate on such issues like abortion. And so in 1994, Mexico adopted a constitutional reform that instated a constitutional court. So that is also something to highlight. It's somehow recent that we have a constitutional court within the Mexican Supreme Court. And mostly since 1994 to 2010, the decisions that the Mexican court functioning on this constitutional mandate were basically based on issues of competency between executive power of government and federal and state authority. And this is really important because the first case that was known in Mexico is a 1999 case called Paulina case. It's a case from the state of Baja California in which a 13-year-old girl had been raped. And at the time, the criminal code and the legislation in Baja California demanded or requested that the district attorney sign an approval in order to start an abortion procedure. The district attorney granted that approval, but the attorney general in the state then prevented the abortion from happening by certain actions. First, they took Paulina and her mom to a priest. The priest talked to them about what would happen and advised her not to have the abortion. They disregarded this and went to the hospital, but then in the hospital, the director of the hospital misinformed her of the consequences of getting an abortion. She decided to proceed with the abortion, but then a person came into the room and convinced her about not getting the abortion, and then she did not get the abortion and gave birth at 13 years of age. In that case, the court established a first precedent in favor, of course, of granting the abortion. The whole country was outraged by this case, and that led Mexico City to be inspired in order to change its law on abortion. And the first law was called Ley Robles, and it established and changed the defenses on a statutory level to avoid criminal convictions on abortion. And one of the defenses that was added through the Ley Robles was the defense of health, in addition to the defense of rape that was already regulated. So funny or ironically, the Federal Attorney General and the Federal Human Rights Commission challenged this legislation, and then this challenge came into the Mexican Supreme Court, who upheld the law on a statutory basis. What the Supreme Court argued was that that the state of Mexico City had authority to regulate on abortion and different defenses, and it upheld the law as constitutional. Then further on, Mexico City again decriminalized abortion in 2007. That was the first big precedent that changed the legal framework. And in that, what the Supreme Court wanted to do is to protect the Mexico City legislation, what they had just enacted. And it basically established a time where abortion was completely decriminalized. And what it did, again, under this logic of state competency versus the federal competency, was arguing that, again, Mexico City had the authority to regulate its abortion regulation, and that the decriminalization of abortion in Mexico City was constitutional. So it again protected that. And then what happened after this in 2007 was that 2011 came another big constitutional amendment and reform, the Human Rights Amendment of 2011, and that changed a bit the argument. It was no longer a legal framework that would just analyze or mainly focus on federal versus state authority, but rather open up a scenario for civil liberties arguments, and concrete cases through the amparo remedy that could now argue things directly from treaties, and other sort of legal instruments, and how they related to the Mexican Constitution and the Mexican legal framework directly in a national remedy like the amparo. The amparo is what we know in the US as habeas corpus. So this is a widely used remedy in Mexico. However, it has the restriction that it only benefits the person who is bringing up or petitioning the amparo. So usually its effects are not generalized, and this is why there are other mechanisms, abstract mechanisms of constitutionality, like the ones that led up to the decisions of 2021, that can have general effects for the whole population. So at the time, new justices also came into the court, because in Mexico, justices are appointed for 15 years. So the court got renewed. It was a fresh vision of the court. The court had new justices that clearly saw the law in different ways and were receptive to the idea of treaties and human rights standards being applicable to interpret our own norms and constitutions. And so, in the Constitution. And so, two first cases came. Those two first cases were about cases of rape and refusal to provide abortion services for victims of rape. The cases went to the court, and in those two cases, the court upheld that women had a constitutional right to live without violence, and that neglecting abortion services was a form of violence, because these women had been victims of rape, and that there was an affirmative duty by public hospitals to perform and provide free and safe access to abortion. That was a first very important precedent that took place, and the first, let's say, like solid block that led into the decision of 2021. The next one was a case about health in 2018, a case of a woman. It's called the Margarita case, in which this woman was 41 years old. She was overweight. She was at risk of her health with the pregnancy, and she repeatedly requested the abortion. She was denied the abortion in public hospitals and finally got it in a private clinic. And in this case, the Mexican Supreme Court determined that health law translated not only into a standard of physical health, but into well-being, physical, mental, and social health. It upheld the standard of health that is enshrined in international legal norms and standards. And it said that abortion is the beginning of a healing process and not the end. And so that as such, in this understanding of abortion, it framed into a health right to health, there was in the eyes of the court a constitutional right to self-determination and decision on one's own sexual and reproductive rights. And so this right to self-determination is the second most important block that leads to the 2021 decision that we're now going to talk about. But before that came, lastly, another case, a very important case, a case of Chiapas, where a person with mental illness that could not speak began to have spontaneous convulsions, and her parents at week 23 of gestation realized that she was pregnant, that the convulsions were in part derived from pregnancy, and that she had been raped. And so the Chiapas Criminal Code regulated abortion in cases of rape until the 12th week of gestation. And in this case, the Supreme Court declared that it was unconstitutional to have a limit on 12 weeks for cases of rape, because the person should have been granted the right to abortion, and to eliminate the pregnancy as means to protect her health and well-being as well. So these decisions that I have just briefly addressed lead up to the two cases. It was actually a set of three cases that the court analyzed, but the first and the third are really relevant as they directly address abortion. The second one addressed the right to life and how it is enshrined in local constitutions. But what the court said in that second case was just that the federal regulation of the right to life is the way that states should regulate it and not beyond it. So it is compatible with these two other decisions that we're going to discuss. The first one is the Coahuila case. The Coahuila case is very, very significant, as Justice Ortiz Mena mentioned in one in one event organized by Harvard University. Justice Ortiz Mena is a justice that drafted the decision, and he said this ruling is very important because for the first time, the discussion about is not about statutory discussion about justification of defenses in criminal conviction, but rather it is about whether women can have constitutional rights. And that is a whole other dynamic, he said. We went from statutory decisions to constitutional decisions, and we went from justification of defenses to asserting the right to reproductive self-determination. And this is why it is such a landmark and very important decision to get to know and discuss, because the Mexican Supreme Court analyzed for the first time whether the use of criminal law to punish abortion was constitutional or not. And although the Mexican Supreme Court concentrated its analysis based on the impact of the right to decide, and it set a standard that I'm going to explain, it concluded that by declaring the article invalid, the article of the Coahuila Criminal Code that regulated abortion and sanctioned it for persons seeking abortions, what it did, the criminal code was sustaining that absolute criminalization of abortion is unconstitutional. So the court said, if you are sanctioning, then there is an absolute criminalization of abortion, and that is unconstitutional. And this precedent is now mandatory for all judges in Mexico, because this case was an acción de inconstitucionalidad, is an abstract mechanism to reach the court with general effects, and the court decided on this resolution by a unanimous decision, which means that it is immediately obligatory and compulsory for all judges. So there are three topics to emphasize in this. First of all, the right to decide and the right to self-determination, and the integration of persons with gestational capacity, and then the other is temporality. So one thing that it is very important to clarify is that the court said that the right to decide is a combination of different rights and principles: human dignity, autonomy, the freedom of development of personality, legal equality, and the right to health, psychological, physical, and reproductive health, and also of reproductive liberty. So all of these elements and rights and principles derive in the existence in constitutional Mexican law of a right to decide. And what it said is that the free development of personality and autonomy and self-determination means that a person has the right to decide in freedom and autonomously their project to life, their life project, and the way in which they will achieve goals and objectives that are relevant for each person. And as such, the exercise of the right to health also include these conditions, like the access to abortion and to freely decide the course of one's own life and reproductive life. And if one has a freedom to choose its own reproductive pathway, then the right to decide is a necessary condition to exercise the right to health. So what gives or enshrines the right to health? What is the content of the right to health? The court established 7 elements. The first is sexual education as a pillar for public policy in health and reproductive health topics. So there should be sexual education everywhere in the country, access to information and counseling for family planification and methods of and contraceptives, access to contraceptives, the recognition of women and persons with gestational capacity as entitled to their own right to decide, the continuation or interruption of pregnancy. Also, the guarantee that a woman or a person with a capacity to gestate can take an informed decision with regards to interruption or continuation of pregnancy. Fifth, the right to decide has a same sector of protection, which are clearly equal and equally relevant, and is the election of the person on whether they want to continue the pregnancy or not. Also, the guarantee of women and persons with capacity to gestate to interrupt their pregnancy in public health institutions with forms that are accessible, free, confidential, secure, expedited, and non-discriminatory. So this establishes an obligation to the public health system to ensure that abortion services can be provided in all these aforementioned ways: accessible, for free, confidential, secure conditions. In expedited, it cannot be just like left there for many days to decide, and in non-discriminatory ways. And finally, that the right of women and any person with capacity to gestate to decide can only understand the right of abortion within what it's called short, it's called periodo breve y razonable. So a period of time that is close to the initiation of gestation. So in that is something that we have mentioned many times, that the court was not clear. Like, what does it mean, a period of time close to the initiation of pregnancy, of gestation? Because it sort of left that to the legislative to decide. The court said, I'm not going to decide where this period or how it is understood. This is to legislators to decide. And the court left it open. So that is something that is a challenge beyond this decision. But something that is very important is that it not only, as we can see, the court really was very clear in saying that reproductive autonomy includes this election, this right to decide, and the free access to any form of contraception and to assisted reproductive methods, and eventually also to abortion. So it is not only a decision if it is clear that the decision is on abortion, but it also enshrines this content of the right to decide that not only affects abortion, but in general, any right to decide on one's own reproductive decisions. And that includes the fact that we can access assisted reproductive methods, contraception, family planning, and also, eventually, if we don't want to be pregnant, the right to interrupt those pregnancies. And so this is the Coahuila decision. Something that I also want to clarify is that the court specifically addressed the sanctioning of abortion. So it said that when the law sanctions any person that tries to access abortion, it establishes by regulating a sanction, it establishes a total ban to access it obstaculizes the right to decide. And this is very important, because then what it does is protect this right in a full way, in a very integral way, and basically it's decriminalizing abortion. And so now what happens after this decision is that this decision basically is applicable to any place in the country, because it is a judicial mandatory rule for judges. However, it didn't immediately exclude it from the legal framework all of the criminal codes in the 32 states that comprise Mexico. So now what happens is that those criminal codes also need to change to be coherent and harmonized with this standard. So it already generated this effect for the state of Coahuila. Mexico has other states that have further decriminalized based on these decisions, and we can go over them later. But there is still a lot pending to do, because this is like 32 states, and there's a big way to go and move forward to generate changes of legislation that will expand this notion into criminal codes, right? So that is the first decision. And the third decision addressed a conscientious objection. Yeah, I think it's very important because it's hard to understand, but the second decision is very quick. The third decision is about conscientious objection. Basically, what was challenged is the regulation of conscientious objection in the General Health Law of Mexico, Article 10 of the General Health Law. And so this General Health Law established in the past that there was a right to object, right? And that it sort of left it in a very abstract regulation. It didn't like comprise limits. It was more, there is a right to object in Article 10 bis. And it established that any medical personnel could invoke a conscientious objection, and that the only exception to that was when there was a risk to the life of a patient or a medical emergency, right? And so this was challenged by the National Commission on Human Rights, and it came up to the court through also an abstract challenge, the acción de inconstitucionalidad. And so basically what the court said is that first, it emphasized on the secular rule that we have for the Mexican state. There is a separation between the state, churches, and freedom of religion, conscious, and any ethical and ideological convictions. So the court upheld that liberty, and it said that this liberty, of course, didn't mean that persons didn't have a right to object. It said that freedom of religion, conscious and ethical and ideological convictions also has limits when the exercise of that freedom can generate an abusive exercise of that right and can impede the exercise of the rights of other persons. So it said that within this freedom, the conscientious objection was not a right that was absolute or illimited, but rather that it had limits, and that those limits were set up by the concurrence of legal protections for special protections in the law, right? For things that must be protected. And so one of those legal protections in the law is the right to health, and that the right to health limits this, is one of those limits to the freedom of conscious religion, ethical convictions, and ideological convictions. And it said that within the protected right to health, it also comprised sexual and reproductive health. And so it said that there were four elements. The court stated that there were four elements necessary for the integral attention of sexual and reproductive health. And one was that there should be medical personnel who is trained and has all the resources to and are qualified to perform any sexual and reproductive health services, and that there should be availability of this medical personnel, and that the services must be accessible to all persons and groups without discrimination or obstacles. And so that this obligation to protect the right to sexual and reproductive health meant that conscientious objection needed to be duly regulated in the law. And so what the court did is set a set of guidelines for the correct regulation of conscientious objection in a way that it won't create violations of the right to health or other rights for other persons. And that will bring a balance so that medical personnel can exercise the right to conscientious objection if they desire, under standards that are also protecting in a dutiful way the right to health, and especially the right to sexual and reproductive health. So what are those guidelines? Is very brief. The court said that the law needs to clarify which is the medical personnel or nurses that will be eligible to exercise the right to conscientious objection in institutions, public health institutions, considering that this right must be limited to personnel that participates directly in certain medical procedures. The law should incorporate a brief time in which this objection can be exercised. So the personnel needs to have a time, but that time should be brief to let them know if they're going to exercise a conscientious objection. It also says that the law should regulate that the person and authority that should decide on whether the objection is approved or not should do it in a brief time as well. And if they don't say anything in that brief time, then it would be understood that it is not approved. The law should also say that it will be prohibited for medical personnel or any medical staff to object in cases where the life of the patient is at risk, or where there is a medical emergency, or when the exercise of the objection can mean an unnecessary and disproportionate charge for patients, an excessive and disproportionate damage for patients. It also said that the regulation can include certain hypotheses to object, and that it should also indicate certain obligations, like the duty to provide services in cases of risk, as we already mentioned, but also what the consequences of those objections could be in cases where they are done outside the law and what the law regulates. So it's very clear. It's very important that it also states something really important, that medical personnel cannot invoke any sort of religion, ideological, ethical, or conscious consideration when objecting. They cannot give that or try to doctrine or teach anything to patients. And that is very important because it protects the right to object, but also the right of any person to access health services. And it is a guideline that is now being disseminated because it's what the court did in this second decision will ensure access to health services, as well as the protection of freedom of conscious religion, objection, etc. That right, like it is a good set of guidelines for other countries that are also seeking to regulate this right in a way that it doesn't vulnerate other rights. So I think that is briefly. Thank you. Sorry, I went too long. But
No, it's okay. Let's move to Natalia and talk about Colombia. Sorry.
So I think it's very valuable to have talk about Mexico first, because The decisions are connected and are similar in different ways. So in Colombia, we don't have a federal country, so the decisions from the Constitutional Court should be applied to all the territory. And it was in 2006 when the Constitutional Court of Colombia, for the first time, referred to abortion in a favorable way. So before 2006, there were other lawsuits that went into the court, but they were not lucky enough to have a favorable decision in 2006. Under the leadership of Monica Roa and Women's Link Worldwide, they presented a new lawsuit, and the Constitutional Court, for the first time, decriminalized abortion under three circumstances, which I think are really similar to other countries: when the health or life of the woman is at risk, when the pregnancy is a result of rape or incest, and when the fetus life is incompatible. So from what happened from 2006 to 2022, a lot of things happened. But basically, the court started to study cases of barriers, cases where providers and insurance companies were doing things that they shouldn't. And the court started to refer to the things that were prohibited under these decisions. So, for example, this is the story of many adolescents and women that were trying to access abortion, but they were denied because providers made up a requirement that was not established in the decision from 2006. This is also from 2006 and 2022. These are the years where the court started to refer to conscious objection and the limits of conscious objections, to the things that they couldn't ask, for example, victims of rape, and the things that were necessary and the things that were not necessary. So this is a story of different individual cases that started to get to the court, and the court started to create the standards of how this should be implemented. So now from 2006 to 2022, it was clear that it was not enough, that decision from 2006 was not enough, because there were many barriers, because we were still trying to, it was especially very challenging to argue when the woman's physical, mental health was at risk. So it was this very narrow and limited comprehension of what health was, and it was mostly about physical health, but the cases of mental health were difficult to prove, or insurance companies were reluctant to accept those cases as included in their decriminalization. So it was clear for the movement and for the feminist movement that it was not enough, and that the court should study a new lawsuit. So this is when the first question that you asked us about the social movement and the green wave, it makes a lot of sense, because in these years previous to 2022, the social movement in Colombia started to work on a new lawsuit, and under the umbrella of Causa Justa movement, which I'm sure you have heard about. And I know that Catalina Martinez from the Center for Reproductive Rights was in a previous episode of this podcast. So I also invite people to listen to that episode. But this Causa Justa movement is a national movement with organizations from different regions, and they work on a new lawsuit that went into the Constitutional Court and under this abstract constitutional lawsuit. And the court took some time, but finally decided this new lawsuit in 2022, and this is the ruling 055. And I'm going to talk about the arguments that the court used in this ruling. So of course, this is a huge victory, because it's a new way of understanding abortion in the country. But just to say that abortion was already decriminalized, so it's not just starting new, but starting with a different framework. I see it like that. So the court basically studied or constructed four main arguments that I'm going to briefly talk about. So the first argument has to do with the obligation to respect the right to health and reproductive rights of women, girls, and pregnant persons. or persons with capacity to gestate. And this was not new. The court had already talked about this in previous like cases and in other in its laws, in its case law from over the years. Sexual and reproductive rights was not new to the court. This is a really progressive court. That's also really an important context. This is the same court that decriminalized euthanasia in 1997, same-sex marriage in the 2000s. So has always been a really progressive court. So the topic of sexual and reproductive rights was not new to the court. And what the court does in this argument is to kind of like update talk about the different and the newish international human rights standards that were not included in the 2006 decision, what the UN committees have said about abortion specifically over the years. And the court establishes that, of course, abortion is a reproductive right of women, and it should be protected also in the framework of the right to health. So that's kind of like the heart of the argument. The second argument that we think it's more it's really like interesting and important to different regions and also to the US. It's the court analyzed how the right to equality of women was being violated because of the criminalization, the partial criminalization of abortion. But the court is not does not limit the argument to women in general, but talk about the ones that were in least favorable context. So this is the part where the court uses a lot of important and interesting data and differentiated data. So I think this is also the part where, like in the previous years, the social movement and organizations work a lot on like getting to this differentiated data and getting to this important research that led to this important argument by the court. So the first data that I'm going to refer is who go to prison. So that's a really important question. Who goes to prison under the crime of abortion still in Colombia? And the answer is really shocking because what the surveys and the research shows and that the court analyzed was that until the year 2020, almost 50% of women that went to prison or were charged for the crime of abortion were under 28 years of age, so they were young women. 31% were minors, so people under 18 years old. And most of the women that were charged for this crime were women in domestic services, students, underemployed, sex workers, and mostly women in rural areas. So what the court says here is like who's being punished for this crime and why the most vulnerable women are being impacted by the crime of abortion. So that's when the argument of equality and women that were in least favored context, it's super relevant. So basically, the criminalization of abortion with consent does not show relevant incidents in the reduction of abortion, but what it shows is the criminalization of the most vulnerable women in the country. Another important question that the court answered in this argument is who dies because of the crime of abortion or because of the criminalization of abortion that makes abortion limited, especially in rural areas or areas with access to health. So the answer is women and girls that face public health problems, and this expose them to complications and unsafe practices that eventually affect their health and even their lives. And here they studied the data of maternal mortality in the country, and that shows that specifically the situation of Afro-descendant women in the country and in the Pacific areas have the highest maternal mortality rates. So that's, of course, super relevant because, again, there's an argument of inequality that it's connected with income, with race, with being in a rural area, with being unemployed. And I'm just going to read really fast this quote from the court, which I think it's really, really important to close this argument. It is rural women, those who have the lowest socioeconomical strata, migrant women, refugees, those out of school, and others, followed by that long etc. that has already been listed in this ruling, the ones that would have fewer resources and alternatives to terminate unwanted pregnancy without the fact coming to the knowledge of the criminal authorities. Here again, the court analyzes that the ones that are being criminalized and the ones that are being affected in the right to health and life are the most vulnerable women. So that decriminalization of abortion especially affects the right to equality. That's kind of like the second argument. The third argument is also connected to especially the decision that Ivonne was talking about, conscious objection in Mexico. And here the court studies, not for the first time, but studies the argument of freedom of conscience. And in a way, historically, the court has referred to the freedom of conscience and conscious objection, especially connected to abortion, but also with other topics in the country. But here, the analysis is quite different. The court says that freedom of conscience refers also to the power of each person to discern between what turns out to be morally good or bad in a given situation. And the decision to have kids or not is an intimate matter closely linked to the system of personal values, ethical and religious convictions. And that is why the decision to have or not to have an abortion, it's closely connected to the freedom of conscience of each person. And this freedom of conscience is one of the main expressions of human nature. It's also connected with freedom of expression and also dignity, because it's your in the most intimate sphere of your life. So both those who decide doing so or not, having an abortion or not, are not only exercising their sexual and reproductive freedom, but are putting into practice their own value of system of beliefs and values. So the criminalization of abortion could end up affecting the most intimate beliefs of people. So that's why it can be a violation of freedom of conscience. So that's the third argument. The fourth argument, and I think the final one, it is closely connected with the use of criminal law, which is something that we are seeing, we saw in Mexico, and we're hoping to see from other courts in the region. It's how courts and judicial systems have to start questioning the use of criminal law to specifically address this topic that is a public health topic. So in this part, the court analyzed that how the criminalization of abortion vulnerates or violates the preventive purpose of criminal law and the concept of ultima ratio, that like the last resort. Criminal law is the last resort. And here they say a lot of things in this part, but I think it is worth to mention some of them. The first one, the court studies how the legislative sector or the Congress of Colombia has had on a mission to regulate in a positive and comprehensive manner the complex social problem of consensual abortion. So here the court says, like, we decriminalized abortion in 2006 and it's 2022 and the Congress has not regulated in any form the abortion or consensual abortion. And the only available legislation in the topic is the criminal code. So that's an omission from the democratic exercise. And you will see that there were a lot of attempts in Congress to regulate the topic after that 2006 decision. But we have a Congress that represents the Colombian society. So of course there's a really conservative wing in the Congress, and 100% of those efforts were not satisfactory, and we still don't have a law that regulates abortion. We only have the constitutional court decisions and some more administrative resolutions from the Minister of Health or things like that, but there was no law until the moment. So the court analyzed that. The court also says that this systematic omission has been tragically evidenced by the Constitutional Court own case law. And here the court refers to those cases, to all those cases that I was telling you about at the beginning that happened from 2006 to 2022. So I think it's more than 15 cases, almost like 17 cases that the court analyzed through the last 15 years. So they basically said that there were 15 years of omissions in the public and private spheres. And the argument there is like this ruling that we have is not enough, because then we're still seeing violations one after the other, cases of real people that their reproductive rights were violated. So it's not enough. The court also said that it was important to have, as in Mexico, other like measures that were not only connected to abortion but to reproductive rights in general. Here they talk about contraception, access to information, access to education, and that's also something to keep in mind, because then we're just limiting this topic to the criminal law, and that is not connected with the spirit of criminal law as the last resort measure. And the court also refers to comparative law, which is really interesting. So they say that in the last years, there's a tendency in the legislative sphere, but also in the jurisprudence, to reduce the use of criminal law and move towards legal systems that protect and guarantee the rights of women. And those legal systems or those legal strategies are not criminal law. And so they talk about different examples, including the Mexican decision, but also they talk about the Australian case, the case of the state of New York, and how Germany, Spain, Argentina, because this happened after the Argentinian law, but they talk about other ways involving administrative and health policies that could be more effective to regulate abortion that did not include the use of criminal law. Just to conclude, the court uses these four arguments and end up saying that in order to protect reproductive rights of women and the right of health of women and persons with capacity to gestate, it was necessary to exhort other branches of power to adopt a comprehensive policy addressing reproductive rights, but also voluntary abortion. And they ended up decriminalizing abortion or declaring abortion legal until week 24, as it is an integral part of the right to health. And after week 24, what happens is that the same circumstances that we have from 2006 are still applying. So we have legal abortion under any circumstance until week 24, and then all those special or exceptional circumstances would apply. So that's what happens in Colombia. Of course, we celebrated the decision, and we think it's a really important decision for the region, and it's a standard that the region should follow. After this, on September of last year, the Minister of Health issued an administrative resolution that provides more specific instructions of how the service should be provided, and all those specific more connected with voluntary abortion without conditions, without obstacles. So I think we have gone a long way from 2006. We learned a lot, and those cases and all that litigation strategies and the research that the organizations did on those years were crucial to end up having this decision. And I think this shows us that the country is in a different time, that the country was ready for these decisions, because we have gone a long way recognizing how abortion should be implemented, and those learnings from the past are being super relevant for the current implementation of this decision. Of course, we're still seeing barriers. This is not like a judicial decision happens and then everything is going to change immediately. So that's why the work of the organizations and that individual litigation and the work that the organizations do with each case, each woman that face an obstacle, it's super relevant. But I think as a standard, it's a really crucial and important standard for the Colombian society and also for the regional perspective.
I love that you wrapped with like lessons learned and like thinking through the lessons, because it leads us right into like the next thing that we should touch on is like what lessons can that you've learned can help you as advocates in this moment. I think, there's things are kind of bleak right now. So like what lessons can you as advocates take?
Yeah, well, this is very important, Jenny. As you mentioned, the decisions are great new standards that bring up opportunities to advocate and bring new legal strategies, of course. But it is also an opportunity to reflect upon the elements that brought into these decisions and how U.S. advocates can bring these elements into the current U.S. context, right? So it is very important, for example, to look at that history of Mexican decisions and Colombian decisions and how the current decisions were built up by other presidents. And something that I think is very important is the issue of discrimination. Like in both decisions, in the Colombian decision, of course, is like a main part of it. But the issue of discriminations becomes so important that the court decides that in both cases, the courts make an analysis on equality. In the Mexican case, the analysis on equality means that by restricting or sanctioning, the law is not granting equal access to a service that will guarantee a right, which is the right to decide. And also, and in that way, the legal framework would unequally treat women and persons with capacity to gestate. That is like the reasoning behind the court. And in a sense as well, the decision on or the analysis on equality and non-discrimination makes it possible to assert a balance of rights in the case of the third decision, right? Like how do medical personnel and any person can both see their rights guaranteed through a balancing perspective. I think looking at elements that go beyond the law, let's say like the elements that surround the practice and material effects of legal frameworks, are also a big lesson from these resolutions. Like how does the court analyzes if a restriction in practice generates an obstacle sufficient enough to generate the dissuasion effect, right? The dissuasive effect, where the person no longer wants to seek a service because they might be sanctioned. And that's what the court also analyzes. Is not, okay, I'm deciding on an interpretation of the law, but I'm deciding on a practice of the law. And I think that is very important for U.S. advocates now. Like documenting, looking at the effects of laws and bans and developments and reforms and amendments can help us gather data and information that can then be a sufficient demonstration to courts on the effects that the interpretation of the law has. And I think that's a new way to bring up arguments. It's not bringing only the ideological side to arguments, the theoretical side of arguments, and of course the development of norms and standards that are taking place at the international, regional, and national level, but rather filling up those interpretations with the practical data that can allow us to shed light into what the context is, and not what the context apparently is, but rather the reality of things and how can that reality bring up change, right? I think that is something that is a big lesson for the US right now and in general for the region, because let's also say that it's not only the US looking for new ways, but also other countries in the Americas who are looking into these decisions to shed light into things that could be done differently. And I think gathering data and analyzing things through discrimination emphasis and through sort of a constitutional approach that brings into the contextual approach is very important. I don't know, Nati, if you have any other reflections.
Yeah, I think I will add, and I think I already said this, but legal change most of the times it's not enough. So we have to protect legal change, like the ones that we have seen in the region, but also work in the implementation, like a sphere, and that's gonna take different actors and civil society, physicians, feminists, different legal movements to work and work to those to make that implementation a real thing. I think also what these decisions have shown is the importance of the intersectional approach as a crucial part of legal and social change. So, like as I show in the Colombia, for example, the context and the situation of my Venezuelan migrants and refugees that were getting into that were arriving to the country, especially in those years from 2017 to 2020s. That was a crucial part of the argument because the court analyzed how the criminalization of abortion was especially harming them. So I think that going back to Yvonne's point was getting this data, getting this information, but with an intersectional approach to analyze who's being hurt the most with this with this criminalization of abortion and with these laws that criminalize reproductive rights. And the other thing that I would say is that we are seeing that after these big wins and after a big decisions such as the one that we saw in Mexico and in Colombia, but also after the law in Argentina, of course, there's going to be pushback. And that pushback, it's going to look in different ways. It's going to look to the more traditional ways of using legal strategies to go after the law in Argentina or to challenge the decisions in Colombia and Mexico. And that's part of what we were expecting. And also it's part of democracy that different groups can use legal strategies and legal tools to challenge things. But there are other manifestations of that pushback, and that can come, for example, in a way of criminalization. And that's something that we need to keep in mind because having these decisions does not prevent countries or authorities to still criminalize women. And for abortion or for obstetric emergencies, and we're seeing that more and more often in the countries, even after these wins. So we have to keep in mind on criminalization and working against criminalization. And this not only affects women or persons with capacity to gestate, but also physicians. We're seeing more physicians being criminalized, and also companions and organizations um, that stay with women in self-managed abortions, for example. So it's something that we need to learn also from this. Like it's not just like we got the big win, the judicial big win, and we're gonna like stay seated and watch. No, we need to keep working because this is never like there's always gonna be something that we need to protect, and there's always gonna be something that we need to work to implement. So I think it's just like a message of encouragement and of like the work it's always gonna be there. So it's better to have strong organizations and a strong movement that it's ready to defend any pushback that we can have.
Oh, I think that's like the perfect like wrap up because I think that that's something that's been really important here is like a lot of people thought like we got Roe and like that was it, we were done. And like, but you need to keep that momentum going and you need to keep engaged in the fight the whole time because the opposing forces aren't going to quit fighting against it. So we need to keep the movement strong. Okay, so I'd like to wrap up my interviews by always focusing on is there something the audience can do? So what actions can our audience take that would be helpful?
Well, I think one first thing is to gather information, disseminate information. Something that is very important is to learn and discuss and generate spaces for dialogue. And this podcast on itself does a great deal on that. We are trying to generate the information, accessibility and availability of the information. And so one thing that I would like to invite everyone is to access our website where we have publications on our work, and also the translations of these decisions will be shortly available there. the decisions that we're discussing in this podcast episode. So I'd invite everyone to visit our website, in the O'Neill Institute website, so that you can find information on these decisions and disseminate. But another thing is just, having short conversations with the people we know. That is, I think, like a very important thing. One of the issues many of us face is like not discussing things that are relevant, and it starts with sharing with our inner circles, friends, family, and start discussing these issues that affect us all. We never know if we will ever be in a position to require medical services, and it is very important to have be well informed and have the correct information to assess those own standings before the information we receive. So I would first invite everyone who is listening to us today to learn more about these decisions, about abortion, about sexual and reproductive health. And our website is one tool, but there's many others, and I would invite everyone to do that.
Yeah, I think what else can I say? I think the invitation is to read the decisions, and we are trying to do a better job with the translation of these decisions, because of course we speak Spanish, we're from Latin countries, but the language can be a barrier. So we're trying to do a better job, like translating the decisions and also disseminating them. But I think I'll put the emphasis on the arguments, because I think the way the arguments by the courts and also the arguments used in the lawsuits were framed, that's a lot of work behind. So I think that construction of arguments can be an inspiration for other movements and organizations that are working in the legal sphere, but also that are working in other spheres. And I think for the region, of course, including the US, but also different countries in the region, we are seeing how having these decisions in Mexico and Colombia has inspired them to push forward and to ask for more. So, for example, we're seeing arguments from the Mexican judicial decisions in Ecuadorian lawsuits or in legislative discussions in Bolivia. So, of course, this is a wave of energy, as you said, Jenny, that it's gonna move in the region and in other parts. So I'll say, like, curiosity for what's going on in other like contexts that is not yours can be a super powerful tool.
Oh, I like that. Well, Natalia, Ivonne, thank you so much for being here. I had so much fun talking to you today.
No, thank you, Jenny, for the invitation.
Thank you. It was a pleasure being here.
Okay, y'all, I hope you liked my conversation with Natalia and Ivonne. It was great to have them both on and learning more about abortion liberalization in Colombia and Mexico. If you have any questions or any topic you would like us to cover, as always, feel free to shoot me an email, and that's Jenny, JENNIE, at rePROsFightBack.com. Or you can reach out to us on social media. We're at rePROs Fight Back on Facebook and Twitter, or rePROs FB on Instagram. Otherwise, I will see y'all in 2 weeks. Bye! For more information, including show notes from this episode and previous episodes, please visit us at our website at rePROsFightBack.com. You can also find us on Facebook and Twitter at rePROs Fight Back, and on Instagram at rePROs FB. If you like our show, please help others find it by sharing it with your friends, and please rate and review us on Apple Podcasts. Thanks for listening.